My name is Salam Abdullah. I am a researcher at the Global Center on AI Governance. So we work to try and make sure that the emergence and rise of artificial intelligence is accessible and equitable for all people. So that includes inclusivity, diversity, etc., but also fundamentally questioning the premises upon which artificial intelligence has emerged and how it is being distributed globally, both as an opportunity and also all the risks that it presents. So this white paper launch is a series of many different launches that we've done across the continent and globally. So we're going to be discussing the white paper that proposes a global Bill of Rights for artificial intelligence to try and address the human rights issues that are emerging with the rise of this new technology. So I think I'm going to give a couple of kind of housekeeping notes for the folks in the room and for the folks online so that everything is accessible and folks kind of know what's happening in the room if they're not in here. So for those of you who are unable to see, that we have over 50 folks in the room in Addis Ababa, and we have around 27 people online. We're going to be starting with opening remarks and then proceed to the presentation that is going to walk you through the white paper. And then we're going to have a short transition where we're going to have a panel discussion with folks in the room who are experts in the field, as well as one attendee online to discuss what the white paper means within the context of Ethiopia, and then within the context of the continent as a whole and globally, and then proceed to a question and answer and networking session. So without further ado, I'm going to invite the first opening remarks by Professor Muradu Abdu from Addis Ababa University Law School to give us some kind of opening remarks before we proceed to the second opening remarks from someone who's very closely working with the Bill of Rights themselves, and then proceed to the presentation. So without further ado, Professor Muradu, if you can come to the stage to give you the opening remarks.
What does it? Oh, okay, okay.
No worries.
Okay, thank you, Salam, for this. Let me say welcome to Addis Ababa, everyone. Of course, many of you are from here, but some have traveled from other parts of the world. Anyway, for all of you, I welcome you to Addis. We are very much happy as Addis Ababa University School of Law to be part of this initiative. Professor Yuval Shany's initiative. Thank you. I think this is an attempt to come up with a global yardstick for regulating the interface between human rights, AI. That's how I see it. This is a noble enterprise from the perspective of the law school. And this perspective, this initiative is expected to be based on evidence. I think this is one of those exercises, and this evidence should really reflect the different insight and perspectives of various parts of the globe. It should not be just a perspective dominated by one part of the world. I think this initiative, this exercise implies that. And this exercise, this initiative, is also an attempt to build consensus, some kind of acceptability, and by basically giving opportunity to various actors to put their own fingerprints. I think this is also, this today's event is part of that consensus building exercise, and we appreciate that. Our school, Addis Ababa University School of Law, established in 1963, and we are having around 1,500 students and undergraduate, graduate programs. We have teaching, research, and community service activities. In all of these activities, academic activities, research and community services, human rights are prominent. We teach human rights. We also research in human rights. We have publications, and we have also we give also services to the community. I think in these exercises we want the role of AI. Okay, how AI is affecting our human rights teaching, our human rights research, and our community services. We're curious. We're interested in that. And we think that we need to align all these academic endeavors with this fast emerging exercise, especially this AI technology. And nationally, we have a policy, a brand new policy, AI policy, which came up in 2024. We have also legal framework, but the legal framework is just focusing on personal data protection bill, and we have also a strategy, 2030 strategy, AI strategy, and finally we have also two institutions, national institutions, directly working on the AI, basically this technology. But when we see this policy, strategy, institutional and legal frameworks, we see some deficits, especially in governing the harmful effects of AI on human rights, generally on human dignity. So in order to basically address these deficits, we need some kind of global parameter. What are the global parameters in light of which we would measure our initiatives? So I think this bill, which Professor Yuval's team is working on, is highly needed in order to address these gaps. I suspect, I have not done research, but I suspect in other parts of East Africa, in other countries, I think there are shortcomings in this area. So how can we really measure and try to fill these gaps? I think we need some ideal international parameter. So we need this initiative. Thank you very much for the team and Prof. Yuval, and this evidence-based and consensus-building exercise is something which is desirable, and it will accelerate, I think, the acceptability of this bill at the international arena. Thank you very much.
Thank you, Professor Muradu. Good morning, Excellencies, distinguished guests, ladies and gentlemen. My name is Yohannes Ayalo. Currently, I'm a postdoctoral researcher at 3 Generations of Digital Human Rights Project, headed by Professor Yuval Shany and funded by the European Research Council. And we are a team of more than 10 researchers based in 4 continents. And on behalf of the co-organizers, the Accelerator Fellowship Program on AI at the University of Oxford, 3 Generations of Digital Human Rights, the Global Center on AI Governance, and Addis Ababa University School of Law, I'm very honored to welcome you all to this special occasion, marking the launch of the Oxford White Paper on an International Bill of Rights on AI, authored by Professor Yuval Shany. And this launch marks the 4th edition of a global series of dissemination events following successful gatherings in Oxford, United Kingdom, Pretoria, South Africa, and Banjul, the Gambia. Allow me to make a few brief remarks on this increasingly important intersection of AI, human rights, and international law. As the author of the white paper and panelists will elaborate in a moment, AI presents both significant opportunities and profound challenges for the realization of human rights. We at 3 Generations of Digital Human Rights Project are studying how digital technologies, including AI and robotics, are helping realize our rights. At the same time, how these technologies also limiting and restricting our fundamental rights. We, in this project, are also advocating for the applications of the existing principles of human rights to the online domain. And also, we are also calling and advocating for the designation of new digital rights in the domain of artificial intelligence. For example, you will hear more in the white paper and from the panelists later, the right to a human decision, or the right not to be subjected to automated decision making, as Professor Muradu also highlighted. The Ethiopian Data Protection Proclamation also has provision on the right to a human decision, and the right to freedom from digital manipulation, the right to access to AI and digital technologies, just to name a few. While states are charting their own digital futures and advancing AI governance through different regulatory approaches, namely rights and risk-based approach from European Union, a government-led approach from China, and also a market-driven approach from the United States, there remains no comprehensive and universally accepted framework governing AI technologies, nor has the international community through the United Nations yet adopted global standards for AI governance. In fact, efforts are underway to develop international regulatory frameworks, although they are moving at snail's pace compared to the rapid pace of technological innovation. In this regard, I commend the white paper done by Yuval as an important contribution to global standard setting efforts. So this white paper centering on human rights-based approach and calling for robust ethical and legal guardrails. It offers a timely and valuable foundation for future initiatives aimed at ensuring that AI technologies are developed and deployed in a ways that respect human dignity and social justice. In closing, while global AI standards are both necessary and welcome, they must remain attentive to regional contexts, subaltern epistemologies, and communitarian values, particularly in the global south. As we shape the future of AI, we must ask ourselves whose knowledge systems, whose languages, whose cultural values are reflected in the design, deployment, governance, and decommissioning of these technologies. We are really very grateful for your presence here today, and I'm really look forward to a rich and engaging discussion. I thank you.
Thank you very much, Johannes, for that introduction. Before we transition to the presentation by Professor Yuval, I just want to confirm with the folks online that they can see both the folks in the room and the presentation. And also, just for as a heads up for folks in the room, we are taking photos, which would be shared on communication platforms. If you do not consent to be included in any of these photos or the recording, please indicate that to me, and we'll just make sure that that is taken into account. So without further ado, I'm just going to invite Professor Yuval Shany to the stage to present the AI Bill of Rights white paper before we proceed to the panel discussion. Professor Yuval.
Thank you. Thank you, Salam. So thank you for coming. Those of you who are here and those of you who are online, it's a great honor for me to be here and speak before you. This is a project that I am coordinating from the Oxford Institute of Ethics in AI. And it also involves my work, like Johannes said, the 3 Generations of Digital Rights, the project that I'm leading for the European Research Council. Since we are talking here about global standard setting, it was very important for me to try to engage as many different stakeholders from different parts of the world both in the process of creating the paper, the white paper that was published last year, but also in the practice of disseminating the white paper and trying maybe to have it influence processes of decision making and standard setting. So before we launched the paper, we did have extensive consultation sessions in 4 different continents, including in the African continent. And after launching it, we have started in a mini world tour of presenting this. And this is, like Johannes said, we've had already 3 presentations in the African continent and 4 other presentations in other parts of the world, including, okay, they have to see me. Okay, now you see me, the people online. And also, we've been also to Southeast Asia, and we are going to move to other places around the world. And the idea is to try, like Professor Muradu said, to try to generate some consensus, some meeting of minds as to how to proceed with the technology, because as you will see, this is not an anti-technology project. We think AI systems are useful, important, and they are here to stay. They're already, we are already dependent on them, and we will continue to be dependent on them. And this is not necessarily a negative development. I think for many people, this is going to make life better in many important ways. But like every other important aspect of our lives, it is important that these developments, that this innovation would not be, we would not rush into it in a way that neglects adverse human rights implications. So we have to remember that this is a technology, bless you, this is a technology that is ultimately designed to promote human well-being. And the main normative framework, evaluative framework that we have in order to assess whether this technology is actually making lives better and is not harming individuals, and the only framework that we have that is universal, inalienable, legally binding, is human rights law. And I find it alarming that in many places around the world, there is a rush to adopt the technology. Sometimes there is also a concerted effort to introduce some regulation, but the human rights implications of what this technology means and how it should be used are often cast aside. They're not at the center of the discourse. So we have global summits on safe AI, which is important. We are talking about responsible AI. We are talking about access to AI. All of these are very important AI and development, but we also need to integrate and foreground human rights into the discourse. And this is what my project is essentially all about. And my interest in this area started when I served on the Human Rights Committee at the UN Human Rights Committee for 8 years. Those were the years following the revelations of the use of online resources for mass surveillance. And it became to me quite clear, and then later on the use of AI in a military context. And it became quite apparent to me that the existing norms that we have, the treaties, the human rights infrastructure is of course a good starting point, but it doesn't actually readily give us the answers. It doesn't readily give us specific guidance. And if we want to ensure that technology is human rights friendly, that it respects human rights, we need to, over time, identify and agree on more specific guidelines. And this is what these projects that I'm involved in are all about. So I want to thank our partners, the Global Center on AI Governance, who's been helping us incredibly to disseminate this program, at the Addis Ababa School of Law at the university for hosting this wonderful event, and also my fellows at the Oxford Institute on AI, Ethics in AI, and the 3 generations of human rights. So what I'm going to do in the next 30 minutes or so, I'm going to present the basic insights that have structured the white paper. What are my assumptions? What are my concerns? What are my policy recommendations? And what specific rights I think we should be discussing as to whether we need and how do we need to develop them. So the first point which I would like to stipulate, my first stipulation is that, and this is certainly not a surprising stipulation, AI is a disruptive technology. It changes quite dramatically many aspects of our lives. It changes the economy, it changes the education system, it changes the health system, it changes politics, it changes transportation. Almost any aspect of our lives are being changed by AI technology and the use of AI systems. And of course, it would be incredible if that wouldn't also apply to human rights law. Human rights law as a normative framework which aspires to govern many aspects of our lives are also impacted by the introduction of AI technology through AI systems. And the white paper lists some of these disruptive impacts. One aspect is information is moving with AI, is being created and disseminated in an unprecedented speed, on an unprecedented scope and scale. We know that in some areas, the introduction of AI technology raises concerns about safety as to whether the systems are sufficiently reliable and robust. We know that in some contexts, the introduction of AI systems affects the level of services that we are able to obtain, sometimes improving the quality of services, sometimes reducing the quality of services. Regardless of whether we are increasing or decreasing, there is a human rights impact that needs to be evaluated. So maybe the improvement of hospital service through AI systems could over time generate a positive duty on governments to facilitate access as wide as possible to patients, to AI systems by patients and by physicians. On the other side, if the quality of service is deteriorated, for instance, if you're no longer able to see a human physician in certain contexts, and you have only to fill forms and have these forms being processed by AI systems, this is a negative externality that we may want to address through human rights law. We've already mentioned this idea of massive data collection. This is a huge disruptive effect of AI systems. The engine on which AI systems drive is information, is data. There is an insatiable appetite for more data. So the more we introduce AI systems into our societies, the more we have to collect personal data. This is really it's one, you cannot have one without the other. And again, there may be good reasons why we want to collect data, but there are human rights implications to living in a world where almost every aspect of our lives is being recorded, monitored, and integrated into AI systems. It's a different ballgame, as the Americans say. There are questions regarding the use of profiling and predictions. AI systems are systems, as we know, that are based on categorizing people into groups and subgroups and making predictions about their needs, about their actions on the basis of their group affiliation. This is a system, therefore, that creates very dangerous frameworks of analysis, profiling, biases that could actually result in us being locked in the different groups that we belonged in. So this is another human rights implication that we would need to address somehow. Many people talk about black box and about opacity, the fact that we do not know how this system operates. And even more concerning, not only we, I mean, I'm a lay person as much as technology goes. I mean, some of my best friends are computer scientists, but I myself know very little about how these systems operate. But even the people who actually build models, build LLM models, struggle to explain why the models generate certain outcomes, certain hallucinations, right? So it's not only black box in the eyes of the general public, which is bad enough. It's also a black box in the eyes or in the minds of the specialists. So again, significant human rights implications for delegating authorities to systems that we ultimately do not understand how they operate and cannot predict how they will operate. This is something that human rights law has to address. Again, I'm not suggesting throwing the baby with the bathtub water, but I'm saying these are human rights implications that may require oversight. They may require safeguards. They may require some bright lines or red lines that we do not cross. Manipulation and thank you. Keep me in the frame. Manipulation. We've always had manipulation, right? I mean, if we would have banned manipulation, there would have been no politics around the world. If we would have banned manipulation, there would have been no advertisement agencies. So manipulation has always been around, but here again, we're talking about a different level of manipulation because AI systems, again, they collect all this information and they identify for each one of us, they can identify for each one of us what makes us tick, what are our preferences, what are our biases, what are our vulnerabilities, and therefore create for each and every one of us a package of incentives and disincentives that will move us in a certain direction, which could be to buy a product, fine, but also to vote in a certain way, or to make another important life choice. So the level of manipulation that the technology now facilitates is again significantly higher from anything we have seen before, and at a scale which is much higher, again, presenting the question, should human rights be part of the conversation about AI systems and the threat of manipulation? Johannes mentioned the idea of human decision-making, and I've mentioned briefly the example of the physician. Do we want to live in a world where you go to a hospital, you do not get to see a human being? You do not get to see a physician. You get to basically present your pain, the way you feel, your symptoms to an algorithm or to someone who would feed it on an algorithm or an LLM model. Do we want to live in such a world? Do we want to live in such a world where university, we would have in universities very few human professors, and a lot of the teaching would actually be done by AI systems? Maybe some would like to live in such a world, but I'm sure that many others would not. And the fact that we are delegating increasingly important responsibility, increasingly sensitive questions about legal entitlements, about financial opportunities, about job prospects to AI systems. This is, I think, changing the ways in which humans interact with one another in organized society in ways that justify, again, a discussion about a human rights angle, a human rights perspective to this question. And finally, it's not an exhaustive list, but the final point which I want to highlight in terms of disruptive effect is the question of accountability. When you delegate decision-making to a system and something goes wrong, who is going to be blamed for the harm that was caused? Is it going to be the person who used the system? Is it going to be the person who bought the system? Is it going to be the person who designed the system? Is it going to be the person who designed within the system the algorithm? It is going to be the person who has put in the training data into the algorithm. What you have is what is called the many hands problem. And when you have too many people responsible for something, the end result may be that no one is responsible for anything. And this is, again, a problem that human rights lawyers and people interested in human rights should be discussing. How do we deal with this new configuration or new accountability gap that had been created through the introduction of AI systems? So the white paper maps some of these human rights risks, some of these human rights potential protection gaps, and then starts to ask the question, all right, we have human rights law. We don't need to reinvent the wheel. We don't need now to create a new Universal Declaration for Human Rights. We don't need a new African Charter. We have these framework in place. The question is whether our existing human rights framework is fit for the task of addressing these disruptive effects, which dramatically change the ways in which societies conduct themselves, humans conduct themselves in society, and all the frameworks around us, the economic context, the social context, the transportation context, the medical context, etc. So the white paper suggests that in some areas, we do not need to reinvent the wheel. There are many aspects of human rights law that already exists, which could be relatively easily transferred and applied to challenges presented by human rights, by AI systems. So if I take, for instance, just the question of the right to health, we do have an extensive treaty language on the right to health in different international instruments. For instance, the International Covenant on Economic, Social, and Cultural Rights that provides that governments are required to ensure the highest attainable level of health to their populations. To the extent that such high level of health requires reliance on AI systems, then governments should be required to take reasonable positive action to introduce these systems, but at the same time, also to verify that these systems are reliable, that they are safe, that they are robust, resilient, effective. So they have to be stress tested. So we know that we are improving the level of health by introducing them and not creating new health risk. And the same, you could apply the same logic with regard to many other rights. So the right to freedom of information is a right that could also be utilized to generate calls to learn more about whether the government is using AI systems, which AI systems the government is using, what sort of prompts are being fed into AI systems, et cetera, et cetera. So it's important for me to clarify that I do not maintain by any means that human rights law is obsolete. Human rights law continues to be the point of departure, and it will provide us relatively readily many of the answers to the questions we need. But then the paper says there are some areas where we need to do some more work, where the language that we currently have in the treaties, that, all of them have been created in a pre-AI era. So the treaties did not anticipate the technology that we are using. So in some areas, what we need to actually do is something that we've always done in human rights law, which is to take general standards, for instance, non-discrimination, and apply them generate more specific standards that would facilitate their application to specific problems or to specific categories of victims. So for instance, we have a prohibition against discrimination in the International Covenant on Civil and Political Rights. But then we have specific treaties on discrimination against women, discrimination against racial minorities, discrimination against persons with disabilities. And the same logic, I would contend, would justify that when we are identifying some specific problems that relate to discrimination and the use of profiling and groupings in an AI systems, we need to develop standards. They could be hard law, they could be soft law. We'll talk about this in a minute. That would enable, would facilitate the transition in ways that would provide sufficient guidance and accountability in this domain of human activity. So for instance, with regard to equality and non-discrimination, we have to have a conversation on algorithmic biases. Okay, the ways in which algorithmics and models can create new forms of discrimination and can create hidden forms of discrimination. For instance, through the use of training data, which is discriminatory and does not capture the needs and interests of the entire population group to which the technology applies. Or with regard to algorithmic design choices that are premised, for instance, on discriminatory assumptions. So for instance, if a factory wants to hire people and wants to use an algorithm in order to identify candidates, and it prompts the algorithm to select candidates that look like our board of management, existing board of directors, to the extent that our existing board of directors is predominantly male, for instance, such a prompt could be discriminatory against women in ways which are hard to detect. So the design choices and the training data and also the use of proxy data are things we need to be mindful of. So we know that in many countries, in the United States, there is a lot of discussion around this specific issue. We know that that an employer can never consider race in job applications. This is a very blatant, this is a suspect classification, which the US Supreme Court would most certainly prohibit. But we know that when algorithms, they evaluate candidate, they don't weigh race. They are not allowed to weigh race or skin color, but they weigh zip codes. And in the zip codes or addresses or high schools in which one had studied. And these innocuous pieces of information actually are highly correlated with race and skin color in the United States. So what you have blocked from the front door, you have, through AI systems, have opened the window for discriminatory policies to come back in. And we have to be aware of all of these specific problems that are associated with AI systems, and we need to develop our equality standards so that they address questions of algorithmic bias and also algorithmic fairness, which include, for instance, the example I gave about perpetuating the existing balance of power. This is something that algorithms, if we want a future to be dictated by the past, this could be very dangerous because the past itself could be normatively undesirable. It could be discriminatory because in the past, we did have many instances of discrimination. Another area where we may need significant adjustments is with regard to privacy, where privacy continues to apply, but many of the basic building blocks of privacy that worked in the offline world before digital technology came into the picture and AI, they don't work in the same way in the online world. And we need to reevaluate our assumptions. So for instance, the example of privacy in public. We did not have in the past a strong sense that when someone goes in the street, walks on the street, then he is entitled to enjoy strong privacy protection. So if we go on the street and a policeman identifies us, this had not been regarded in the past as a violation of privacy, because the assumption was that privacy is protected in a private space. But when one goes out to the town square, one implicitly renounces the privacy protections that one was entitled to. And if someone meets that person and recognizes that person and even takes note that he saw that person, this is not part of our legitimate privacy expectations. Of course, this doesn't work anymore in an era of facial recognition and an era in which all our coming and goings and all our location data is being fed and reserved and is easily retrievable from computer systems. And in that kind of context, we need to be speaking about protection of privacy in public, maybe as much as we need to talk about protection of privacy in private. Or another example, historically, in the common law jurisprudence, there was a sharp distinction between protecting the privacy of letters and removing protection of privacy from the envelope. So when you write on the envelope an address and you send it to someone, we do have US case law that says there is no legitimate expectation of privacy when you are sending a letter, with regard not to the contents of the letter, but with regard to the information on the envelope, because this is something that you would expect all the world to see. This distinction does not work with data and metadata. I mean, there have been initially some cases in the United States that took the position that data is protected, so our emails are protected, but metadata about the emails, who sent the email, to whom, from where, and what was included in the email, were there photographs, or with regard to a text, how many kilobytes or megabytes were in the message. This is not being, there is case law that suggests that this is not being protected. We know today that actually we can learn much more about people and about who they associate with and maybe where they are and what they are doing from metadata than from the actual data. The emails could be very technical and could reveal very little about our personal lives, but who are we connected with and who are they connected with, and how often do we correspond with them, and from where. This really requires us to reevaluate our understanding of privacy, and the list goes on and on. Just one more example, encryption. Encryption in the digital era had been seen like a very important asset that would enable us to remain anonymous. It protects our privacy. It protects our freedom of expression. In an era of AI, we may sooner or later reach the point where encryption is no longer useful, because AI systems could reverse engineer encryption, decrypt them, and remove our privacy protection. So if we want to actually maintain these sort of protections, we would need to regulate decryption technology, so it would not be able to remove our encryption technology. So again, the balance of power is changing, and we need a discussion within privacy that would be sensitive to these new technological developments. So that's the second layer. So first layer, we apply existing law. Second layer, we adjust existing law. Third layer, and this is where it gets even more difficult, is that there are some areas in which we do not actually have the proper frameworks in existing human rights law to adequately deal with some of the new challenges, the new threats to human well-being that is created by digital technology. So I've already mentioned black boxing. We do have a right to freedom of information, but that right applies in a very specific context vis-a-vis governments. We do not have an all-encompassing right to understand computer systems or AI systems. And this is arguably an area where human well-being is on the line. Because if we don't understand how AI systems work and we do not have the capacity to understand how these AI systems work, then what I call in the slide, our epistemic well-being is compromised. We have few tools to understand the world around us. And as a result, it would be difficult for us to challenge the processes by way decisions have been taken if we don't understand them. It would be difficult for us to identify that our rights have been violated if we do not have access to the decision-making process that led to a certain outcome. We do not have, also, like I said before, it's not obvious if we do not understand the decision, who is accountable for the decision? On whom do we actually place the legal responsibility for a decision that harmed us? So having systems that are increasingly influential in our lives operate as black boxes may require a new response and the emergence of new rights. For instance, a right to algorithmic transparency. We know that within the technology, there is a push to create explainable AI. But we know that explainable AI for the time being has many limits. There may be, as a result, a push to first a requirement to put more efforts in the direction of creating explainable AI, but maybe limitations on the use of AI in a non-explainable manner in certain contexts, in certain areas of life, for instance, in a judicial context. We may not want to use AI systems that would decide innocence or guilt in a situation where we cannot understand how these systems operate to the fullest. Like I said before, also concerns about manipulation are not adequately captured by existing law. And as a result, we may need also to create a new right or derive from existing rights a new right to be protected against algorithmic manipulation that is related both to our interest in data integrity, so that we are able to identify what information is truthful and what information is false, that we would have the basic capacity to distinguish between the truth and the untruth, but also, like I said before, our cognitive integrity. We do not want external actors to play with our mind, to manipulate us, and to, in a way, deprive from us our ability to make choices in the world. This is a very fundamental human need that is captured by the right to human dignity. And finally, in this list, I would say, is the right to a human decision-making, or the right also to a human-to-human interaction, where many of the concerns which I've already alluded to come into play. There are concerns about bias when machines make decisions. There are concerns about safety, reliability, and effectiveness. There are concerns about the quality of the process. There are concerns about transparency and explainability. But there are also concerns about human empathy. We want to live in a world, I think many of us want to live in a world, where we have the ability in sensitive and important context to engage with another human being that can extend empathy to us, that can imagine herself or himself in our shoes. This is why we want a human judge. This is why in some legal systems, there is trial by jury, because there is a sentiment that one needs to be judged by one's peers. So of course, trials by jury have many other problems, but the sentiment is strong. And I think removing that from human society, from human existence, is going to be extremely costful. And like I said before, when machines take decisions, we may end up with no one to blame, with no one to incur moral responsibility. Now, all of these insights, which I have alluded to, which I have mentioned, I think are well reflected in existing regulatory instruments. So in a way, almost everything that I said could be reflected in laws that we have in some countries, in declarations that were made by some regional organizations, by some UN documents. So we do have already within the regulatory sphere instruments such as the European, like the EU AI Act, or the EU GDPR, or the African Union Malabo Convention. I mean, many of these sentiments are already there. Johannes mentioned the data protection law applicable here in Ethiopia. So we do have norms that require access to technology. We do have norms that talk about safety. We do have norms already in domestic law about data protection. We do have certainly an interest in many instruments in AI and algorithmic discrimination and transparency. We do have in some instruments concerns about manipulation. We do have in certain laws concerns about automated decisions. We do have a requirement for accountability. So almost everything, all the problems that I have mentioned, we can find, not in a comprehensive way, not in a human rights context, but we can find in many regulatory instruments around the world solution to these problems, which underscores maybe that these are real problems, that people who have applied their mind to these issues did identify, did concede that we need to do something about this, and have adopted legal instruments that go in that direction. So just to give you an example, we do have a Council of Europe Convention from 2024 that does identify 7 major normative requirements pertaining to AI systems: equality, privacy, reliability, safety, accountability, transparency, dignity. We do have an EU AI Act, which outlaws, for instance, the use of certain facial recognition technologies in public, also prohibited practices of social scoring, that is basically creating for each and every individual a score on the basis of how data collected about him suggests that they are pro-antisocial. This is the stuff of science fiction, but we are already seeing some aspects of it play out in certain parts of the world. We do have, like I said, specific instruments in different regions that do take on board data protection. They do take on board the right to human decision-making, the Malabo Convention, the GDPR, the Council of Europe Convention on protection of individuals regarding personal data, the AI Act, the EU Continental AI Strategy that emphasizes the need for monitoring and oversight, the draft African Convention, the African Commission study on human and people's rights and artificial intelligence, which also takes on board many of the problems and solutions that I alluded to. Even in the United States, the Biden administration has proposed to create an AI Bill of Rights that already captures some of the major problems that we talked about: safety, anti-discrimination, privacy, transparency, and human decision-making. This is, as you can imagine, not part of the existing White House policy. This belonged to the previous White House. But the fact that you have lawmakers and regulators and lawyers and philosophers from different parts of the world coming around these ideas does suggest that these are indeed universal problems that would require universal solutions. And then we have also, I don't have time to go into this, but we're starting to see national laws and national strategies emerge that take on board, again, many of these insights, the need to regulate specific aspects of AI systems in ways that would be conducive to protect human well-being. And again, you see it's all over the place. It's here, it's in other places in Southeast Asia, it's in Europe, it's in the United States. The problem, and I'm moving towards the end, I'm conscious of the time. The problem that we have with what we currently have is that we have norms that are splintered. they're not universally applicable. So, for instance, the Council of Europe Convention hasn't even entered into force, and it's not likely to attract all the big actors anyway. The norms that we have are by and large not human rights norms. They don't use the words, the language of human rights. They don't use the structures of human rights. So even the GDPR, that is a very important regulatory instrument that protects privacy rights, data protection rights, protects the right to automated decision-making, doesn't even talk about human rights. It talks about the rights of data subjects. So even the terminology suggests that the norms, the instruments do not address us as humans. They address us as data subjects, right? As entities that have control over data. We can be human, we can be not human, we can be corporate, we can be persons. So there is something, I mean, I don't want to sound too critical, but slightly dehumanizing in this framing of the issue. And even when you do have rights, and it's important to have rights, even if they are not human rights, they need to be strong rights. So the GDPR, for instance, right not to be subject to human decision is a right that is very easily waivable. So you can sign it away in a contract, and a state can legislate around it. So the fact that you have a right that is so easily removable suggests that this is not really a human right. It is a weaker form of right. And since we are talking about significant threats to human well-being, we shouldn't satisfy with a second best framework. We need a human rights framework to protect our human rights in this regard. There is also a question of specificity. So some of the norms are drafted in ways that move the needle only to in a very limited way. So I'll just give you the example of the Council of Europe Convention from 2024 does say that each party shall adopt or maintain measures to respect human dignity and individual autonomy in relation to activities within the life cycle of artificial intelligence system, which is, everyone can agree to that, but it doesn't really tell us much about what should be done. I mean, it's articulated in ways that are so general that they are not, they do not go significantly beyond what we already have in human rights law. So we need actually more specific guidance. At the same time, the EU AI Act does have very specific guidance, but it doesn't even identify what rights are implicated. So we need something that is not too detailed and not too general, something which is in the middle. And this is how normally human rights treaties are articulated. They identify a principle, give concrete guidance, but then leave the rest for application and interpretation going forward. I have two more slides. One is to suggest that the problem that we have is not only, so far I've dealt with problems of normative fit, whether we have the right that was created in 1948 or 1966 or 1981 could simply apply to a new technology. We have to acknowledge that the problem is not only normative, it's also institutional. The power has shifted. Human rights were created to constrain governments. Governments are still a source both of protection, but also a source of concern. But when we are talking about AI systems, governments are not at the driver's seat. It's companies that are at the driver's seat of the technology. So we need a human rights framework that would be sufficiently specific and flexible to deal with the private duty holder problem. So this is an additional reason why we may need to go beyond the four corners of our existing instruments. We should also be thinking about significant power gaps and digital divides, which go again beyond the traditional concerns of human rights law. There's a question also of who is going to actually produce these laws. Do we want judges to do that? Some say yes. I would say be careful what we wish for, because if judges go too far, they would be accused in many context, for instance, in the European Court of Human Rights, of judicial activism, of basically frustrating democratic expectations of constituencies. We see a backlash these days against the European Court of Human Rights on issues relating to environment and immigration. And I'm not sure that it would be suitable to delegate such difficult and important acts of balancing to unelected judges. There is also a question whether any individual government could effectively regulate a technology when, you know, some of the companies are larger in terms of their economic cycle than most governments on the planet. So if we would take the top 10 digital companies and look at their and regard their economic cycle as if they were a state, they would be the third largest state on the planet in terms of their economic output. Only the United States and China would be larger in terms of their economy than the top 10 digital companies on the planet. Can a small country or a mid-level country, such as the UK or Ethiopia or Brazil, can they take on these giants? So here again, we should think of how we deploy global standards as maybe the only way out, the only way to tackle these sort of challenge. I would also, maybe we can get to that in the discussion. I would also say that traditionally in human rights, we dealt very much in a victim, we protected victims. This was the core focus of our work. Here, I think even identifying victims is something that's very difficult because a lot of the harms are obscure and dispersed. So we need to deal with human rights issues at the policy level, not at the implementation level. The final slide that I have for you is just to conclude by saying the white paper deals with all of these issues. It, like I said in the beginning, it's based on a series of consultations in different parts of the world. It does recommend at this point in time 7 rights, which partly reflect existing human rights law as adjusted to the needs of protecting individuals from harms that could be inflicted by AI systems or ensuring that individuals could enjoy the benefits of AI systems, right of access, privacy-related protections, freedom from bias and unfairness, algorithmic transparency, right not to be subject to manipulation, right to human decision and interaction, and right to accountability. And the other recommendation that we have in the white paper is about form. The consultations made it quite clear that at this point in time, there is limited appetite and also limited prospects for success for developing a new treaty. Therefore, the proposed approach, and we can discuss this again at the Q&A, is to go for soft law, for a non-binding articulation of principles. And we have some very interesting and impressive precedents to hang on to. One is the Universal Declaration of Human Rights that started as a non-binding declaration by the General Assembly and later on became the treaties, the binding treaties, and also the Business and Human Rights UN guiding principles from 2011 that have also been adopted as soft law, but over the years have inspired many other initiatives, including legislative initiatives within states. So once a good idea, if the idea is good, if a good idea is legitimized through soft law, I hope, and others involved in the project hope that over time it could graduate into hard law, although I would say the time is not on our side. The technology is moving extremely fast, so we cannot wait decades and decades. We would have to find ways, everything is moving speedily now, and we would have to find ways to generate relatively quickly the soft law instrument and then transform it where needed to hard law instruments also relatively quickly. Thank you very much for your attention, and I look forward to hearing comments later.
There we go. Thank you very much, Professor Yuval, for that presentation, and for folks in the room and online for attending the paper that is going to be framing our conversation today. So I realize that there are conversations that are happening in the chat, and I can imagine that there are also folks in the room with thoughts that they'd like to share. But before we extend it back to the room, I'm going to invite a couple of experts in the room and also one online who are going to discuss this white paper within the context in which they work. So as I introduce folks, if you are in the room, if you could please come to the stage. And if you're online and I introduce you as a speaker, that is Dr. Kabene, please turn on your camera, and we will also do a quick mic check with you. So first, we have Dr. Fitsuma Samino-Andarge, who is the principal investigator and the director of the Resonance AI for D Lab at the Addis Ababa University. And Dr. Fitsum is a computer engineer and researcher at Addis Ababa University, where he leads the lab and also serves as the founding head for the Center of Artificial Intelligence and Robotics. And his work is focused on applying responsible artificial intelligence that is also context aware, and the scientific and societal outcomes in health, agriculture, governance, and energy. So Dr. Fitsum, onto the stage, please. We also have Dr. Abdi Jibril Ali, who is the commissioner at the Ethiopian Human Rights Commission. And since his appointment by the House of People's Representatives in June 2021, Dr. Abdi has been responsible for civil, political, and socioeconomic rights. And Dr. Abdi has been elected as a member of the United Nations for the Economic, Social, and Cultural Rights. And the term begins in January 2027. Thank you, Dr. Abdi, for joining the panel on stage. And lastly, for folks in the room, we have Wendemage Goshu, who has their Bachelor of Laws from Addis Ababa University, LLM for University of Oslo, and PhD at the Institute of International Law and International Relations from Austria, and also has an MPA from the Harvard Kennedy School. And their work focuses on various topics that extend from constitutional law to human rights law, and was also the head of the School of Law for a short while. And applause, please, and then we can move to online. Yeah. So online, we have Dr. Kabene Wadajo, who is a visiting academic at CSLS at the Faculty of Law at the University of Oxford, and she's a lecturer and associate for the Institute of Business Ethics at the University of St. Gallen. So let's start first with Dr. Fitsum. So I realized that you work quite closely with emerging innovators who are trying to use AI for development in the broader sense. So applications of artificial intelligence in agriculture, governance, health, etc. And as you can imagine, these are kind of areas that are quite risky as it pertains to human rights. And if you could speak to the different human rights issues that are emerging, both within the context of how artificial intelligence could potentially address human rights issues, and also the human rights challenges and risks that are coming up with the different domains that the Resonance Lab works with. Can you use that mic?
Thank you, Salah. And I will start by Professor Shany for actually writing the document in a way that us engineers could understand. I will start from a working experience I had about I look at the problem and all I care about is like how to solve. So I was invited to participate in a policy discussion workshop, and it was about privacy. And so in that discussion, I presented how our technology can be used to issue privacy. And I was pretty satisfied with myself. Of like, I have solved this problem. Like this, if you do this privacy, and person sitting to me, next to me, like I've seen him like write notes, and there was like, and and he actually gave his thought, and he said, he's a lawyer, and he's from Brazil, and he said, if we just use the technology that he described, the companies that are going to say implement this whatever AI technology, they're going to say, okay, they have followed the prescription that this technology needs to be implemented, and they say they are not responsible for anything else. It's like, it was a shocking revelation for me, because I only like looked at the problem from the point of view of like a solution, but like how it could be abused was not a consideration for us. And that's how it is like when it comes to like computer science engineers, when they like solving a problem, they usually focus on like how that problem addresses a certain specific like task or problem. However, what we have learned from our experience is that when we're designing like solutions, we need to consider responsible like guidelines. But that is, we are also think of like human rights and how the technology that we develop is going to affect the users. And again, I'm going to tell you another experience that I learned from Salam. And Salam, we asked her to give like training for our engineers and computer science on responsible AI systems. And in that discussion, somehow the question of energy use of AI came into play. And this was just around after the grid was inaugurated, and we have like all this power that in Ethiopia like we could use. So if like idea is like if we can have AI data center here, and like how we have the energy that we produce. And she raised the point that shocked us. And like, and we know like when we say that Ethiopia has like about 40% or 6%, I don't know that like which number, is not electrified. Even where it is electrified, we don't usually use it for say in household like say cooking and stuff, right? And she said, do you realize that it's the women that actually have to do the cooking, and they don't, I mean, if we remove this energy and use it for, say, like AI, that they don't have access to clean energy, and they're the ones that are affected. And what this actually like led us to believe is that we're very clueless. We need help, right? We need help. And that help, like in this kind of discussions, and also like we have to include teams of like say people that actually understand the issues, the social issues when we design. And that's why actually I appreciate one of the recommendations Professor made was to include human rights and social aspects in the development pipeline of AI systems. That way, we can ensure safe systems like this. And that has been our experience in the development solutions. And I hope this answers your questions. I didn't directly answer it, but I answered it from the experience and the things that we understood. So thank you.
Thank you very much for that, Faisal. And for folks in the room who are not familiar with our work, I think one of the research areas we try to focus on is what are the actual societal and environmental implications of artificial intelligence on the actual, the different like livelihoods that exist, right? So this includes rural livelihoods who have to carry water from different natural water resources to their homes. And as we know, and as a feminist researcher for me, that is women, right? So for that, when we are thinking of the cooling systems, if we think that the right to water and the right to access to water is a human right, then that becomes an issue of different kind of rural-urban divides as well as gendered implications. So thank you so much for raising that, Fisum. If we could hear from Dr. Abdi on what does it mean for human agency or autonomy to be threatened by artificial intelligence? I think we're trying to think about what does autonomy mean in the more kind of in the abstract sense, which means in how these systems affect the ways in which we think, the ways in which we access information, and how much freedom we have depending on what kind of information is being targeted to us. So we've seen that online systems have kind of catalyzed different conflicts, both within our country and also on the continent and beyond. So how does the threat to cognitive agency and cognitive autonomy affect the safety and security of Africans and Ethiopians as well?
Okay, thank you very much for the question, as well as for the opportunity to be part of this discussion. It is true, AI and other technologies, emerging technologies, do affect human agency. One of the ways it has been doing so is through manipulation that Professor Shany very clearly also raised in the presentation. So because of the misinformation, because of the disinformation, and now because of the deepfake, even in cases of advertisement and others, for example, measures and subliminal influences do affect our agency in several ways. One of the ways that we can respond to that is, I agree with Professor Yuval Shany, is to create a separate right against manipulation, the right not to be subject to algorithmic manipulation. So that sort of manipulation has a real impact on the ground, and that example is Ethiopia. So coming to your question related to the conflict in Ethiopia. So I take the example of the conflict in northern Ethiopia between 2020 and 2021, where, for example, the Ethiopian Human Rights Commission in the Office of the United Nations Office of High Commissioner for Human Rights authored a joint conducted an investigation and authored a joint report. And in that report, they clearly identified that social media platforms are one of the catalysts or one of the factors that exacerbated the conflict during that time. Even international organizations like Amnesty International went further and identified Meta, the parent company of Facebook, for the harms that was caused, identifying individuals that actually Meta and Facebook contributed to the conflict in Ethiopia during that time. And even there are, based on that conflict, there are even cases, not in Ethiopia, but based on cases or conflicts that happened in Ethiopia. Now cases are before Kenyan protests that was brought by individuals that were harmed by the acts of Meta and the Facebook. So the good thing is the Kenyan court said that it has a jurisdiction to hit the cases, although Meta isn't operating, or it doesn't have offices in Ethiopia, or also the fact the conflict didn't occur in Kenya. That's quite something positive. But we do not forget also the power dynamics that Professor already raised, the differences between the power, whether it is the litigants in Kenya, those Ethiopians, because their names are out there, Sadakle and also Abraham Mara, who were also part of that litigation. So it is having a real impact. Also led to the days of individuals in that instance. So it is impact. I would say the impacts of how technologies or AIs and algorithmic manipulation manipulate how we respond, how we lose agency in making decisions is having an impact on individuals to an extent of causing harm up to the days of or loss of life. So it's very difficult in that sense, and the repercussion, the impact on life, including loss of life, is a big challenge for us in Ethiopia and also elsewhere. I hope I responded.
Yes, thank you very much for highlighting that there are material and at times kind of violent risks to what these algorithmic systems can result when it comes to both social media platforms and beyond. And if you would like to share the research that you mentioned to the folks in the room and those online, we can share it after the event as well. So if I could bring Dr. Kaveni back into the room. Dr. Kaveni, are you with us?
Right, yeah. I'm here.
Okay, the volume is quite low, but I will try to. There we go. So some of your recent work discusses how the adoption of different national and also regional AI strategies themselves can be understood as AI governance, or a form of AI governance rather. So how can different AI strategies, including those that are adopted in Ethiopia, as well as the African Union's continental strategy, contribute to the implementation and realization of the International Bill of Rights that was presented earlier today?
All right, thank you very much. I hope you can hear me well. Am I audible?
Yes, you are.
All right, okay. Thank you very much to the organizers, and as well as congratulations to Professor Shany and his team on the launch of the white paper. And thanks, Salam, for the question. So maybe where I want to start is, I think this directly goes into what the soft law, hard law kind of point that was already raised during the white paper presentation. AI strategies are inherently finding hard law instruments, but they are not also just mere policy instruments. They have a significant governance capacity. That's primarily because, and that's the reason myself and others who were involved in that work needed to focus on, or to start with, what kinds of instruments are being introduced in the African continent, including Ethiopia, and strategies seem to be quite popular currently. And the important thing in their governance capacity is tied to how they set priorities, for example, and they indicate institutional responsibility in the labor division within that, as to like who has the governance capacity and who does what, and also defining the national ambition and vision, and shape how states understand the relationship between technological development, and in this context specifically AI systems, and their international human rights responsibility to protect, respect, and fulfill the right of individuals and people, and in line with their international obligation, but also in line with the Banjul Charter. So this clearly tells us, even though strategies are not necessarily binding instruments, but they are precursors to the binding laws that are introduced at the national level. So, for example, if we look at the very recent OECD report, in Africa, so far we have a bit over 20 African countries with AI strategies and policies, most of them introduced after 2023, with the exception of 4 countries, which includes Mauritius, Tunisia, Rwanda, and Egypt, introduced their strategy and policy between 2018 and 2022. And within that, when you look at this document, you see the kind of balancing that the states are trying to do between, for example, human rights-based approach versus developmentalist vision versus security-anchored, state-led and state-controlled AI development and deployment, or more market-oriented, innovation-led approach. So here we can see the different multiple interests that arise from governments, that is also influenced by multiple other actors, including donors, as well as private actors, corporations, and also geopolitical concerns. So all should really shape, and they are really significant and important. And in light of this, for me, the hard law and versus the soft law debate, especially in the legal space, might not be strongly helpful. We cannot insist on saying we only need hard law. Rather, we can leverage, as already pointed out, soft laws, whether this is in the form of, for example, guiding principle, strategy, or policy, that will help us to tailor and inform more concrete hard law as we proceed. Of course, the time is of essence in the context of AI development. Everything moves so fast, and we might not have enough time, but at least that is one approach, and that's why we focused on the strategy. And if I may very quickly touch on the relevance of the white paper in this context, is the white paper can help us, particularly here, in balancing between what is mentioned, two general principle oriented. For example, the Council of European Instrument, the framework is one example where it speaks about the human dignity, privacy, and things like that, but in a very general term, human right, even though it uses human rights language, but also other instruments are quite technical and quite detailed, such as the EU Act, which is inherently, by the way, not a human rights instrument, but it is a product safety instrument. It's a market integration instrument at the European Union level. And these instruments kind of sit in these two extremes. So what the white paper helps us, and I think what we can take as a lesson in the African context, is that where is the middle ground in here? For example, how can we find AI-specific human rights norms that is fitting to the African context, to the African need, as well as to the African values. So since we already have some of this, both in the African regional instruments, but as well as the African judicial and quasi-judicial bodies jurisprudence. So perhaps I'll stop there. Thank you.
Thank you very much, Dr. Gavani, for highlighting how these instruments, even though they are not binding per se, set priorities as to what kinds of directions we're heading in terms of the implications of artificial intelligence, both within the continent's context or the respective national context in which it operates. So back to the room to Dr. Windemaging. If we discuss the different kind of legislative frameworks or legal frameworks, a lot of the challenges, particularly within the African context, is enforcement. And a lot of the challenges with that come with the institutional and socioeconomic realities within which these kind of legal documents have to exist. So what kinds of lessons can we take from previous kind of frameworks, and which institutions do we have on the continent and in Ethiopia that can help us realize similar bills to the white paper's proposal for the International AI Bill of Rights? So how can we try to take lessons from previous kind of gaps and fractures, and what institutions can help us do that?
Thank you very much for the opportunity. I should thank Professor Yuval and his colleagues for this important initiative, particularly in the pattern for international law. Norm setting, patenting, global promotion doesn't have to exist anymore, and so on. it is an important initiative, and Africa will learn from this, contextualize and probably adopt various kinds of instruments, whether they are hard or soft or useful version kind of understanding of AI and human rights promotion. In African context, let me quickly itemize a couple of points. One is it is important to see the state of protection of human rights in Africa. That is very important. If the protection is good, it is likely that our promotion in the age of AI would be good. If not, it is likely that our challenge would be multiplied as well, particularly in Africa, where there is lack of governmental commitment. There are violations by governmental organs. It is likely that the state of human rights would go worse in the age of AI. So, one important thing to do in Africa is to assess the existing challenges and address them together with the new challenges. So there are traditional challenges, particularly violations by the government. Now, the new technology has might multiply those challenges, and we need to act on the basis of this important state of affairs in Africa. Another important consideration is the language of human rights. Here in Africa, although in policy instruments we agree on universality of human rights and so on and so on, in practical terms, we are not even convinced of the language of human rights. I'm not blaming each and every state, and all of us, there are some states, governments, committed to human rights and the language of it as well. But we have to understand, we have to underline in Africa that our talk of human rights is not against technology, against compute power, physical infrastructure, AI development, AI data center, and so on and so on. So our promotion of AI and human rights should be understood to be integral part of our promotion of technology, our promotion of AI. It is important that Africa promotes AI, sovereignty, from tier AIs and so on and so on. In individual African states, they might not be able, but through the scheme of African integration, we can promote African compute power, African frontier AI, African data centers, and so on and so on. So human rights should not be taken as against technology and AI. Otherwise, one important challenge we could see, there are research, is a capacity challenge, for example. If we try to prevent or remedy or enforce the violations of human rights by AI, do African countries have the capacity, for example, to monitor Meta or any other frontier AI company? We have very limited capacity. In fact, we have to actually work together in Africa if we are going to have a chance of protecting Africa from violations of human rights owing to AI. My last point would be the question of commitment. In Africa, there are a number of research regarding Africa and African human rights. Our principal challenge is commitment. Commitment in terms of norm setting, but more important, commitments in terms of compliance and enforcement. For example, we did studies on the implementation of African human rights instruments. The reality is the implementation gap is very huge. So in Africa, we need to be serious that in addition to norm making, adopting AI Bill of Human Rights or contextualized AI African Bill of Human Rights, we need to commit for implementation and enforcement as well.
Mm-hmm. Thank you, Dr. Wadimagi, and for speaking to what the value of commitment even when enforcement challenges persist. And I think one of the instruments that could help us, and forgive me for I'm biased, but there is an index that measures the responsible AI called the Global Index on Responsible AI that the Global Center on AI Governance works on, that is coming out this July, that tries to measure what governance principles and also different actions that governments are doing in order to uphold human rights principles when it comes to artificial intelligence. And I will ask our team to share that in the chat. In the meantime, let me come back to Dr. Filsoom. And I understand that there are some technical folks in the room and virtually with us who are wondering what kind of design principles, so whether that be through institutions or enforcement, can actually help innovators who are keen to implement AI for development in a manner that upholds human rights and also in a manner that doesn't create new risks and harms. So what principles are actually actionable for those who are working in the technical side of AI for development in Africa?
That's a very tough question to answer. Okay, so I think I should answer it from what is being proposed in the document. And there are a list of human rights, like human rights that the era of AI should be involved. So right to so when the digital era came into being, there was this digital divide. Right? Then there was a huge move to ensure that the divide does not happen. So here we like one of the proposed is that right to access to AI systems. Now this also goes hand in hand with like the digital divide. So like governments can manage this, right? Governments have to work hard to create access. However, when it comes to like the question is that the companies that are like producing these AI tools are multinational. Like they are like they're not bounded by boundaries, right? So there is a potential for harm, like if they decide or whatever they want to do with the data in the AI systems. So what we can do is like there is this push, like Dr. Magin said earlier, about having our own AI systems, right? Like so sovereign AI. Now, another issue is that we should actually work on is data sovereignty. So this is actually even mentioned in the document that the AI systems are data hungry. So they need data. So they go everywhere where the data is available and they try to get it like through normal means or like indirect means, right? As long as they get the data, they don't care. They just make they want to make the models better, right? So we have to work towards like ensuring that the data, so it's ensuring that the data is so the data is like protected. When I say protected, it should be like available for sovereign AI. And one of the things that for example, if in country like people like us that develop the data as AI systems, sometimes we find it even difficult to get the data. Now, but a company like say 8,000 miles away has somehow access to that data, right? So like we need to figure out a way that local like researchers, local companies that would like to develop like sovereign AI have access to it, and we can improve like the challenges like you were saying, like which is how do we ensure that human rights are protected? Now, when I say these human rights, so I also agree with like what you were saying earlier, Dr. about like the language. So the universal language, and then when it comes to the like the say Ethiopian reality may not match. or like African reality, it may not match, or like Asian reality, it may not match, right? So we have to take it down and like make it our own, like make it in the way, in the culture. So that's when it, like that comes to AI itself as true. The AI systems, when we build them, like when we build them, for example, we build it in such a way that like they understand. One of the problems, like for example, we work on some like with Federal Supreme Court on some AI, like challenges they have, and also we work with a law school, like Leah works with us, and like one thing she mentioned was that when people litigate in the courtroom, some people use enigma, right? They use parables, and like how do you ensure that the AI systems understand that? Unless we are the ones that make it, right? We can put these nuances in the system. So I would say in the design, at least for us, we have to consider our own conditions, our own realities, and we have to have precedents to ensure that these realities are incorporated in the design. I think in our method of labs, like to ensure, say, responsible AI development, I think there is one approach called assets. That is, it's a framework that we could follow to ensure that whatever solution we're producing is responsible. So, and it's built by Professor Jerry in Ghana, and like I think others as well. So we could maybe share that as well, so that people could follow to like produce responsible AI. Thank you.
Thank you very much, Dr. Fizzle. Just as a heads up for folks to speak into the mic so that people online can hear, but a couple of also contextual information for those who may not be aware. The network of labs that Dr. Fizzle was referring to are the AI for D labs. So these are a series of different labs that are across different countries and across the continent as well. And a lot of these labs are trying to figure out what context appropriate artificial intelligence means. So this includes kind of the different linguistic nuances that were mentioned, such as scanning parables, double entendres, and also different contextual interpretations. But if I may add to Dr. Fitzgerald's point, I think that we should also contend with what the risks of exposure mean. So what does being identified by these systems actually mean? Do we want to be known by a system that has yet to be governed? So I think we need to contend with both points at the same time. And if I may return to Dr. Kabani online, could you tell us the practical obligations that technology companies and platforms have when AI tools are being deployed on the African continent in a manner that respects humans and people's rights in line with the Bill of Rights proposal that was presented earlier today? What does this practically mean?
All right. So thank you, Salam, again for that question. Well, I mean, one place to start to respond to this question is to go about to this question of whether private companies are subjects of international law and international human rights law, right? So in principle and technically speaking, international law governs the relationship between nation states. Therefore, technically speaking, private companies, particularly technology companies, are not subjects of international human rights law in principle, right? However, this has been questioned and has been challenged, and increasingly we're moving away from this narrative in recent years. And earlier there was a mention of the UN guiding principle on business and human rights as a good example. For example, here, if we look at the UN guiding principle, which also, by the way, speaks to the technology aspect, has 3 pillars. So the first pillar simply reiterates the existing human rights obligation of states. Those already exist under the Declaration of Human Rights and the two covenants. But then the second pillar speaks to the responsibility of business or private actors, and it explicitly sets out, for example, how can companies undertake practically their human rights responsibility. There is a little bit of tension here between the use of the term responsibility versus duty. So the guiding principle use responsibility because there is this still an understanding of corporations are not subjects of international law and international human rights law. But so for me here, I will use interchangeably between obligation and responsibility. And so practically to undertake their human rights responsibility or obligation for companies, they are expected to undertake human right due diligence throughout the life cycle of their business activity in different wherever they are. So this is not territorially limited. And this includes first assessing, identifying, mitigating, and remedying any potential or actual human rights harm that may result from their business activity or from their business operation. And normally they are expected to do so before, in the tech context, the deployment of, for example, a given to the market. So this gives us a certain practical leverage. But that said, this is still a soft law, or it's a guiding principle that is giving birth, if I may frame it this way, to binding national laws. For example, this not yet in the African context. But if we look at different legislations in the European context, there are mandatory human rights due diligence requirements or obligations. For example, in the French context, in Germany, in other countries across Europe, we see binding instruments being introduced at the national level that will require companies to undertake human right due diligence assessment throughout the life cycle of their business activity. So this gives us a practical leverage. But also when we come to the African context, we actually have already in place some instruments, but also the jurisprudence of the regional human rights decisions. For example, here I can think of the decision by the African Court of Human Rights in Trafigura case. This is about waste dumping in Cote d'Ivoire, a decision that was made in September 2023, where the court by majority vote decided or concurred that multinational corporations or transnational corporations are obliged to respect international law. And particularly for me, what is interesting in this case is even the dissenting opinion in the judgment went to an extent of saying there should be a direct liability of corporations for their human rights obligations through a horizontal application of the African Charter or the Banjul Charter, specifically Article 27, which impose actually a duty on individuals. And individuals here are interpreted to very broadly, not just an individual actor with a human blood and flesh, but also a private actor, corporations being one legal private entity operating in a society, would be expected to undertake their duty in the African context towards, for example, a family, a society, the state, the legally recognized community, as well as international community. So if we look at the African instrument in this context, we actually have a tool that we can leverage to extend very practically to subject companies to responsibility in this context. The Anvil mining case decision by the African Commission is another excellent example, and I invite our audience to look at that, and so that I won't spend time to go into that detail. But so practically speaking, technology companies, we can say, who deploy and design AI systems in the African countries should have very clear obligation in the context of their human rights obligation, but also conduct a human rights due diligence, at least not as a box ticking or ethics washing or human rights simply a compliance mechanism, rather genuinely as their duty that to which they would be held accountable, and should conduct. This will help them, I would argue, to ensure that systems are tested against local language, for example, social context, and also protect characteristics, the social characteristics that matter, for example, to avoid any proxy information-based bias that can be integrated through the model design as well as data, and also provide transparency and meaningful explanation and guarantee access to human review and remedy, and avoid exploitative data extraction. And these are all listed and explained also in the white paper. So yeah, I'll just stop in the interest of time. Yeah.
Thank you, Dr. Gamini. So I think this really helps us try to figure out what this practically means within the existing legal instruments we have. And in the interest of time, and also to invite folks in the room to ask questions if they have any, I'm going to ask Dr. Abdi and Dr. Wondemagin to respond to one question and to kind of integrate it to both of your expertise. So I think there have been efforts at a continental level to try and both understand the implications of artificial intelligence on human rights. So this includes the draft study that was published by the AU's Commission for Human and People's Rights, and to try and understand it and respond to it. So what is the role of continental and regional bodies in both trying to understand the human rights implications of artificial intelligence on the continent, and also how can we use the existing frameworks and institutions at an African level to respond to these new and emerging risks that we are discovering. And then I'll direct it to folks in the room and folks in the chat to ask a couple of questions before we go off.
Okay, thank you.
Much closer to the mic, please.
Okay.
Yeah.
Okay. So yeah, continental institutions, how do they respond? That's how I understood your question. Through the African Commission on Human and People's Rights that was established to oversee the implementation of the African Charter on Human and People's Rights, issued a resolution. Then later on, a draft study that was published last year. So it clearly explains both the positive implication of AI and also the negative impacts of AI on all categories of rights, civil and political rights, economic, social, and cultural rights, as well as what the African Commission or the Charter is regarded as people's rights. So the study clearly identifies those categories of rights and how it is positively and negatively impacted by the AI, robotics, and other emerging technologies. So if I take, for example, economic, social, and cultural rights, it clearly identifies how, for example, AI affects the right to work that's recognized in Article 15 of the African Charter on Human and People's Rights. So it is true that it positively contributes in creating jobs. So for African youth who are trained in engineering and technologies, that is true. But unfortunately, AI is a technology that displaces more jobs than it creates because it gives more job to the machine than to the individuals. That is one of the challenges that the study identifies. But also the problem with, for example, platform workers. So you create a job in Africa, but that is usually comes to a platform and the companies, the technology companies that connect different categories of customers, whether it is taxi hailing companies or whether it is content moderation. So it is creating a different kinds of problem for human rights, including the right to labor. So now individuals are losing jobs even then we can take the examples of how Meta outsourced the content moderation to some as a subcontractors, and individuals lost a job in the process of transferring from one contractor to the other, so which is a loss of right to work. So those individuals are also exposed to harmful content. So in that sense, we are having a new problem. So does the institution like the African Commission, Continental Institution contribute? I would say yes, in several respects, particularly in AI. It's not because the African institution and African countries contribute much in terms of creating AI and emerging technologies, because it is the African states and African continent that's affected most by the use of these technologies, as evidenced by platform workers. So the Commission already saw the study proposed several institutional as well as normative development. So, for example, a declaration on the use of AI and emerging technology could be one step. The development of model laws could be another, and even the development of framework convention could be another. And in this regard, both the African Commission and the African continental bodies that the African Committee of Experts on the Rights and Welfare of the Child, or the African Court on Equal Individuals' Rights, do contribute to the norm creation, and for that matters also implementation of the African Charter and other international human rights treaties adopted by the African Union to adapt those treaties to the realities of the digital world and the digital technology. That's what I say. So.
If you may.
Okay, Dr. Abdi said a lot. I just want to add one or two points. One is my
Sorry, if you want to put like
the criteria should be whatever African mechanism we employ, whether we rely on the Commission's jurisprudence or guidelines, declaration, or hard law treaty, and so on and so on. Effectiveness must be the criteria. I think Professor Yuval understand what it means. I met him first time in 2014 in a meeting relating to the effectiveness of international law with the American Society of International Law. Since then, I always applied the criteria of effectiveness to be evaluated, whatever regional, sub-regional, or national institution standard, and so on, we apply. So one is effectiveness. Which one is effective? Effective means actual grassroots implementation, compliance, and enforcement of the standards we promote, whether using soft law or hard law. That is one. The other thing is the commitment I mentioned earlier. So are African countries committed to the adoption of AI, Bill of Human Rights, for example? That might be a question. In Africa, from my experience, we are eager to adopt norms, policies. I'm not sure how many of you know, but in Africa, the African Union, there is an implementation report every 6 months, for example, and implementation reports indicates Africa is lacking in implementing its policies, or even treaties, guidelines, and so on and so on. So commitment plus effectiveness should guide us as to whichever approach we choose. And again, provisional, interim, and long term. The long term, it should be kind of a treaty binding, but otherwise African states should commit and kind of domesticate whatever standards set at the regional level. Thank you.
Thank you very much, Prof, for the response. So I have a couple of questions online, but before that, if I may extend it to folks in the room, I see one person behind and then one person here, and then I'll see if there's overlaps in the chat and then go. If folks are keen to stay a bit over time, we would really appreciate the conversation to extend publicly. So I'm just going to go to the back and work my way to the front, okay?
Thank you, Sana. Hello, everyone. My name is Halifat Mohammed Yusuf. I am a lecturer at Willa University Law School. Good to see everyone here, and especially my former professors, Commissioner Abdi Jibril and Dr. Wandamage. My question is directed to Dr. Fitzou. Given your commitment to responsible and context-aware AI, I would like to ask you about the Ethiopian context. So, because AI and digital technologies become increasingly integrated into governance in public lives generally, what measures are being taken or what measures should be prioritized in Ethiopia to address emerging risks such as technology-based violence against women here in Ethiopia? Particularly against women human rights defenders, and to ensure that AI development contributes to a safer and more rights-respecting digital environment. Because as we know currently in Ethiopia, there are women who are planning to end their life because of AI-generated image. So I would like to know your, any information that you have regarding this, or even if we have to maybe draft national laws concerning technology-based violence that's happening against women. Thank you.
Dr. Fitzou, if you'd like to respond to that, and then we can move to the next person.
You raised a very valid question. Unfortunately, this is the tool is enabling, but the problem is not the tool. How do I say this? Is someone that targets a person, is it not? And kind of the culture that like brings the tool brings up the wars because it enables that kind of behavior. And I mean that happens like with any kind of technology that comes in, like when it lands in the hands of the wrong person, it like people use it against each other. And one of the things that was raised earlier, like moderation, you could use the tool to moderate as well. And one of the rights that was written is the right to non-manipulation. And this is just one form of manipulation. I don't think it is in the policy right now, but it should be. And we should advocate towards that. And any platform that we create, we should put so if we cannot afford human moderation, we should put at least tools that could identify this kind of things and protect the users. And I know I'm proposing like a technology to combat other technology, but we should also put it in the laws and in the policies to ensure that whoever does this is responsible for that act. Because, like, say for example, if I abuse someone verbally, I'm responsible for it, right? And social media actually, or like the internet, gives me the chance to hide behind something to do that. But I think we should use the technology as well as the laws to protect. I would say that. And another thing is like whoever likes building the technology should really consider these issues and put the guardrails so that this doesn't happen. So, yeah.
Sorry to interject, but I think there are a couple of resources that would be helpful to the really important question that Halifat raised. There are research projects that the Data Workers Inquiry project is working on. So this includes both data workers and researchers globally on a participatory research project to try and document and also call for just labor conditions for data workers. As it pertains to harms against women, I think the thing that I want to add to this one's response is defining tech-facilitated gender-based violence legally and trying to have accountability and redress mechanisms is one of the areas that we're seeing underperformance, particularly on the continent, but globally. So I think those are also calls to action that I want to add. But I think we have one more question in the room, and then I will bring it to the chat. And then one person, I know you're sitting together, if you could merge your questions, that would be amazing. Thank you. Go ahead.
Okay. Hello, everyone. My name is Kanakida. I'm a human rights educator and advocate, also teaching at the Addis Ababa University Law School. Thank you, Professor Shany and other members of the panel for excellently outlining many of the major issues and challenges posed by AI systems for human rights. But I believe one major challenge remains in the sense that AI systems also challenge the very idea of what it means to be a human being. Because nowadays we're witnessing, the blurring of the line between humans and machines, because human beings are increasingly, some people are integrating AI systems and technologies in their body. So who is a human being, really? And also, what does the right to a human decision mean when we are dealing and interacting with someone who is, let's say, I don't know, 50% AI or technology and only 40% flesh and blood human? So I think this is very important. Normally, human rights apply to humans, but in the future world, or even in the present world, in some cases, in some areas, we are dealing with people who claim to be augmented humans and people who claim to be, cyborgs, who have integrated with machines and artificial intelligence systems and trained, bound to accelerate with the development of, for instance, PCI technology, brain-computer interface technology, such as Neuralink. This will have, for instance, direct implications, as an example, for the right to work. How can someone compete with, let's say, a cyborg who's directly accessing the internet or computer systems in his mind, So because of a chip he has put in his mind. So I'd like the panelists or Professor Shany to address this question. Thank you.
Okay, thank you very much for that really interesting question. I'm going to merge it with one question that emerged online. So I think the question is essentially put is, how do human rights apply when the question of humanity itself right now is being contested, or there are attempts to contest it, or there are perceptions that it is being contested? And there's a question online that asks, how can we approach access to AI as a human rights issue, as kind of different access to technology, etc., have also been in the past. So as AI is a continuity of different digital technologies, how can access to it be addressed in human rights matter? So I'm going to extend it to Professor Yuval first to speak to both, and then invite the panelists to contribute if they would like. And we have one last question in the front here, and I will encourage, perhaps our communications team can gather the questions in the chat, and we can try to respond to them in the post-event communications to kind of let folks go to their other commitments. Thank you.
So thank you. First, I want to thank the panelists. It was really a wonderful discussion. Relating the question, the two questions. So the first question is very difficult. And it's very difficult because you are rightly alluding to an increased blur the respective contribution of humans in AI systems. Now, you're talking already about what is a future development, maybe not so far in the future, because I've actually been involved in a project that looked at enhanced humans, which has this dimension, and that was in a military context. It's a very troubling concept. But even now, when we are dealing with, when we are working and we are using AI systems in order to improve our academic papers, not to mention that we are grading our students' papers, it's already very difficult to evaluate what part of the work has been done by the human and what part. So in a way, we're already in a world in which you have this unclear dividing line between what a human being does and what a human being doesn't do. And that is why I think we will have to identify certain guardrails and certain bright lines and certain no-go areas. And I would just underscore the point that even some of the solutions we have may not really work, because a lot of the solutions that we find have to do with human oversight. But if machines are so much more advanced in their data analysis capacity than human beings, they can process much more information in a much shorter amount of time. Introducing a human into the process is going to be like basically putting a speed bump into the process. And I think in some areas we will have to take the normative decision that we will do that. We will dumb down the systems so that humans can effectively monitor, and we will slow down the systems. But in other areas of life, we won't do that. And then the question of how do we preserve the human element is going to be a huge question. And this is why I think we should have, as stakeholders, we should have discussions as to where do we want to draw the line. And currently, when we are not having these discussions, the lines are being drawn for us. It's not that the lines are not being drawn; they're simply being drawn without our involvement, and this is the concern. And on the issue of access, I think fundamentally here is that this is an area where human rights actually has a good track record, because we do have in many, electricity was mentioned. We have the same questions when we are talking about economic, social, and cultural rights, and the need to ensure access to basic infrastructure. So we think about sewage, we think about water systems, we think about electricity, and then came the internet, and we were starting to have this idea of right to access to the internet, applying the same framework. And I think we can extend this framework also to right to access AI. But of course, AI has this additional dimension of literacy, which so it's not just to introduce the systems, it's introduce the systems in ways that would be accessible to as many people as possible. It's also to reform our education system in ways that would, train individuals to be able to perform in such a systems. We talk a lot about digital divides as a north-south matter, but also within countries, you have huge divides between different populations on the basis of socioeconomics, on the basis of age. You have this whole discourse about digital natives, young people who grew into technology, and digital immigrants who are older people who grew up when the technology did not exist. And we will have to address all these issues, but also the cost factor, because the companies are introducing some bifurcated, trifurcated, quadrifurcated systems, where if you want to use the more powerful engines, search engines, and more powerful models, you will have to pay more, and that would already create. So when we think about the right to access, we have to also think about these dimensions. But this is the one area in human rights law where I feel pretty confident that we have many of the building blocks.
Does anyone on the panel want to add to that before I pass it on to the final question?
No.
Would you like to take
One important point is the question of access to AI. AI by itself and its instrumental value as well for education, health, and so on. This is an important area where we could collaborate the technology people with human rights people as well. I think we should enhance our literacy. Lawyers and human rights advocates are literacy in technology, AI, at least the basics, and the technology guys as well on human rights. So we could create a kind of a dialogue forum. I think this is the starting point, but we have a dialogue forum and ensure access to AI. From what I can see, access to AI for countries like Ethiopia is possible if we have developed our national capacity. Otherwise, we cannot force foreign companies for AI access? How could we ensure access, for example, with the good thing of data drive, for example? Why are we not having the frontier AI for Ethiopia, for example? We don't have data. We can have this technology people, we can have a national drive for data collection, of course, protecting privacy and other important rights.
We have one final question in the room before we go off.
Thank you very much for this opportunity. I have a question.
Introduce yourself.
Sorry, my name is Hanna Manai. I am an AI ethics researcher for health innovation. But my question is going to be something, I really appreciate the opportunity to have a locally based expertise on the panel. So I wanted to bring the discussion to digital ID, and which we can assume will be subjected to AI technologies now or in the future. And as we know, is a core pillar in a global South context. It's a core pillar of digital public infrastructure. Not the same maybe in the US, for example. It's just part of, let's say, a national tech stack. But here, considering the important points that all the speakers have raised, namely the power gaps. The power gaps in terms of, again, the narrative of digital ID as a developmental solution compared to, again, just a tech stack within governance. The risk of this specific population, maybe not our specific population, but the risk level as a society that we have to digital and tech-based harms. The lack of transparency on Gen AI as a technology in its own nature, but also in the future. What does adding my personal data, my digitized biometric data and other personal identifying information to generative technologies would look like in 20 years, 30 years, 50 years. And then of course the weakness, this is related to the weakness in informed consent. So do I know, can I say I'm really informed in my consent if I don't understand what that data will look like as an output or an action 30 years from now, 50 years from now? I just wanted to know what, particularly Dr. Wandemagin, and if she's still with us, Dr. Kabane, on how you envision that the discussion and the risks around human rights, digital ID, and AI in the future.
Sorry for that. If we could invite Dr. Kabane to respond to that, and then we can move to Dr. Wandemagin before wrapping up.
All right, so can you hear me? Am I good?
Yes,
Okay.
you are.
All right. Okay. So yeah, thank you very much for that question on digital ID. And this has been really a critical issue, and it has been debated, in particularly, for example, in the context of India, as well as the Huduma number in Kenya, right? So the key challenge in there is, so the digital ID is generally a part of the public infrastructure that is pushed basically at trying to integrate like different public services to modernize administrative work, and it's really global project to specifically even give it in some of the locations that I am located personally. For example, there was a vote in Switzerland last year on digital ID, which first it was not passed, but then later on it was approved, and particularly because the digital ID project was primarily shaped and it was primarily conducted by private companies. The infrastructure was provided by private companies. Later on, they revised and then they changed everything, and now the state seems to be at the center. This then made the people to trust the infrastructure a little bit better. But for me, the central question is, when we speak about digital ID projects, what are we talking about, like the kind of affordance that we are talking about, both in the context of human rights, but also in the context of human affordance that it impacts. So Digital ID as a technology has its own affordance, meaning its own benefit to a society in terms of modernizing administrative works and efficiency and things like that. That's well and good, but when it comes to governance and regulation and also scholarly engagement, I think one critical question that we need to ask is what human affordance is being compromised in the process of digitalizing every aspect of human livelihood. So we often seem to overlook that, and I think that is a missing element. When we speak about consent, for example, is to what extent is the consent that is given, for example, when we sign for digital ID is well informed, and to what extent that is actually was an alternative to opt in and to opt out. Do we really have an option to opt in or to opt out? If we don't have that, then can we actually talk about consent in that context? So there are different, and this goes into the human rights element. So this is very general response, but because I'm putting it very generally because it's very complex area to engage to kind of dissect in detail. But I would like to point you to really look at different reports that were put out, and also a court decision in Kenya on Huduma number, but also in India, the Aadhaar ID number. So which is especially the Aadhaar number is used as a model to deploy digital ID in many countries across Africa now. So just to point you to some resource. Yeah. Thank you.
Thank you, Dr. Kabani. Dr. Kabani.
Okay, to briefly reflect on the question, the question raised, I mean, technology is a kind of double-edged sword. You can use it to promote human rights, or you can use it to violate, particularly if the government is involved. As I said at the beginning, if the government is keen to violate, abuse, and so it is likely that whatever technology accessible to government is likely to be used for abuse of human rights, for violations of human rights. So what we can hope for is there a process that guarantees governmental organs in their undertaking for public interest and so on. Digitization is important, we know, for policy making, planning, economic growth, and so on and so on. So when we use those kinds of technology, what are the guarantees not to violate fundamental human rights, for example? Is there a judicial review? Is there a monitoring mechanism? I was asking Dr. Abdi actually if there was some mechanism of monitoring privacy as well, but he might comment on his individual capacity. I'm not sure. But guarantees are very important. Otherwise, it is legitimate to be skeptical of the digitalization drive. And it is likely officials, abusers, I'm not saying it is a state policy, but it is likely. So we should watch out for such kinds of violations and others, providing some guarantees under the Constitution and statutory instruments.
Do you want to add anything?
Okay, thank you for the questions too. So when I will make it very general, when it comes to technology, usually they are created with a good intention to improve human life in general. So just like any other thing, it's an individual who used that for a bad cause or with a bad intention in that technology. So the question comes particularly to an institution, particularly when we talk about human rights, we're talking about the state, unless we move to, the issue that Professor Shany already raised, that private institutions, multinational companies are more powerful, and for the state it's very difficult to rein in or control this or to hold them accountable. So the question, you need these technologies, including digital IDs for access to services. And for example, the Ethiopian Human Rights Commission, we were promoting for registration of IDPs and refugees for a digital ID so that they will access the services, whether that is health, education, and the like. But the problem is if the institution, they are supposed to protect, even the laws are coming a little bit later. Personal data protection, if you see it came later or after the digital ID proclamation. So even the way the government moves in terms of institutional capacity and in terms of legislative development, it is far behind, whether it's at national level or continental level or at international level, far behind the speed with which the technology is moving. It is that capacity that we are lacking. So final point on, for example, again, technology facilitated gender-based violence. It is our problem. I mean, as a society, not only in Ethiopia or everywhere else, that the discrimination against women, including violence against women, is rampant everywhere. And the technology is also, for some, is being used. So we at the Ethiopian Human Rights Commission brought together human rights defenders, including women human rights defender and the police officers who are supposed to be violent, investigating and bringing those individuals to justice, to the book. So the problem is, again, lack of the capacity. So it's not like these police officers do not want to bring those individuals to book or to hold them accountable. They just don't have, they don't know how they can do that one. And they also don't have the institutional capacities, including technology instruments. So that's the challenge that we are having. Thank you very much.
Thank you very much for those responses. Thank you everyone for staying an extra 30 minutes. I will take that as a commitment to trying to realize the ambitions that the white paper outlines and the conversations that we're having here today. I'm going to delegate to our communications team to handle the online conversations, making sure that that carries forward, whether that be just by sharing our video recording, but also reserving the questions in the chat so that we respond to them in due time.